In this video we consider acceptance and what an offeree must do to validly accept an offer which has been made to them. This is quite a straightforward topic, and there are a few general rules with respect to the communication of offers and how you're to communicate offers, but there are a couple of exceptions to those general rules which do require a bit more of an explanation, which is hopefully what you will take away from this video. In terms of our plan then, we're going to start by looking at the definition. We're going to look at the definition in such a way that we break it down into three different parts, and then the remainder of this video will focus on those three parts. What we will really focus on towards the end is the rules which govern communication of an offer. We're going to look at the general rule that an acceptance must be communicated to be valid, which comes from the case of Entours, and we'll look at the Lord Denning decision in that, and then we'll look at the exceptions to that general rule. As with all of our videos, we're just going to start with a bit of perspective. We're still talking about contracts coming into formation, and we're now at the point where, generally speaking, the contract would be formed by that acceptance of the offer taking place. What we will talk about in the next video is the things that must surround that, which is the intention to create legal relations and consideration and capacity as well. Breaking down acceptance then into its constituent parts, on the next slide we're going to discuss the definition of an acceptance, and when we see that definition you will see that it breaks down roughly into the three parts that you can see on screen. That it has to be in response to an offer, and that's quite an easy thing to understand, and there's not much case law that you need to know on that particular point, but you just need to know that the acceptance is being made in response to a specific offer. The next thing that we'll discuss is that it has to be unqualified. What we mean by that is it must exactly match the offer being made. The way we describe that is the mirror image rule. If an offer is set out with a set amount of terms, the acceptance must exactly match that offer for the acceptance to be valid. If the acceptance is qualified in some way, what we call that is a counter offer, and the effect that a counter offer has on the original offer is to destroy it, to take it off the table so that it is no longer capable of being accepted, and the case for that is Hyde and Wrench. That's a very famous case and one that you will always see popping up in a contract law exam when you're talking about the contract formation question and counter offers destroying original offers. What we will also focus on there is making the distinction between a genuine counter offer, such as Hyde and Wrench, and what is a mere request for information that's not trying to counter the offer that was made. It's merely trying to clarify it. And an information request does not destroy the original offer like a counter offer would. So it's important to be able to make the distinction between those two things. And then the final thing that we will look at, and which is the bulk of this video, is the rules that surround communication of offers. As I said in the beginning, the general rule comes from the Lord Denning decision in Entours that it must be communicated to the offeror, and that's when the contract forms, which is one of the key points in that case. But there's exceptions to that, and the primary one that we will look at is the postal rule and all of the little sub-rules that surround that. So there's plenty to talk about when it comes to the communication of acceptance. So in our previous video we discussed the definition of an offer, which is that expression of willingness to contract on certain terms with the intention that it becomes binding as soon as it is accepted to the person to whom it was addressed. We're now looking at the other side of the coin and the definition of that acceptance itself, which again, the academic definition that we have here is an unequivocal expression. So that's the first key part. It has to be unequivocal. It cannot be qualified, of intention and assent to the terms of an offer. So again, in response to the offer that was being made, which is communicated to the offeror, who is the party making the offer. So again, the acceptance comes from the offeree in response to the offeror. So I've added a bit of emphasis to the three main parts of that definition, and we've just highlighted them on the screen. So the remainder of this video, we're going to be marching through the three elements that you can see there, starting with the fact that the acceptance has to be made in response to the offer. With respect then to our first requirement, which is that an acceptance has to be made in response to an offer, I think this one is rather straightforward, and that's the fact that the offeree, who is the person to which the offer was addressed, it is they that must have knowledge of that offer, and it is they that must accept it. You can imagine why this rule exists. It's designed to protect the person that made the offer, the offeror, because they are making a very specific offer to a very specific person. They don't want any third party to be able to come in and accept that offer and to snap it up. They made the offer to a specific person. It is that specific person that must then accept it, which is where the basis of this rule comes from. So hopefully that is quite straightforward. It is linked with a principle that we will discuss later on as well, and one of the rules of consideration that we look at in the next video, that consideration must move from the promisee, but we'll park that for now and we will talk about that in the next video. The final thing then, which people often ask themselves, is does the motive for accepting an offer matter? And the answer to that is no. We have a very interesting case for that, which is Williams and Carwadine. In Williams and Carwadine, it's all about Mrs. Williams here. Her husband, as it turns out, murdered the brother of Mr. Carwadine, who was the defendant in this case. Mr. Carwadine, the brother not of the deceased, had put an advert to say, if you come forward and you identify the murderer, I will award you £20. Now, we discussed in the previous video the requirements for what's known as a unilateral offer. That was exactly what that was. It was a promise to pay £20 in return for a specified act identifying who the murderer was. So Mrs. Williams was on her deathbed, and this is where the motive factor comes into this. She was on her deathbed and decided, you know what, I want to clear my conscience. I know who murdered Mr. Carwadine, the brother. I'm going to go and claim that reward as part of clearing my conscience. So she did exactly that. She pointed out who the murderer was, who turned out to be her husband, but we'll not get into that. And she went to claim the £20 off the brother, Mr. Carwadine. He tried to argue that she had some ulterior motive for accepting that contract, and because of that ulterior motive, the contract should not have formed because her acceptance was not valid, and the court did not entertain that. They held unequivocally that motive does not matter. As long as the offer is accepted, it doesn't matter why you accepted it. So that's what the rather interesting case of Williams and Carwadine is all about. The next requirement that we consider then is the need for the acceptance to be unqualified. It must match exactly the terms of the offer that was made. Again, linking back to our definition of an acceptance, it has to be an unequivocal acceptance and assent to the terms of the offer. So it must be unqualified to be valid. This factor or this requirement is sometimes referred to as the mirror image rule, which does exactly that. The offer must exactly mirror the acceptance for that agreement to take place and for that contract to form. As an examiner myself and someone who sets law exams, this would very often be one that you see on the mark scheme of a contract formation question, for the simple fact that it's very easy to write it into the fact pattern of those questions. You will see parties trying to buy and sell things on the facts. One party offers and negotiates something else, and that ultimately turns into a counter offer, and that's where you need to be citing the case of Hyde and Wrench, which we will discuss now in terms of its facts. So Mr. Wrench, back in 1840, offered to sell his farm to Mr. Hyde for £1,000. So that was quite a lot of money back in the day. This was a serious transaction. Mr. Hyde replied, offering £950, so again trying to haggle a little bit, trying to negotiate, and the point is that that was not an acceptance. That did not match in that mirror image way the offer that was made by Mr. Wrench, and therefore no contract formed at that point. The £950 was not an acceptance, it was a counter offer, and as we will soon see, what a counter offer does is it destroys any previous offers that were made. So we will see that shortly. Mr. Wrench refused. He did not want to sell the farm for 950. He wanted the £1,000. And because Mr. Wrench refused the offer, Mr. Hyde tried to turn around and accept the previous £1,000 offer that was made by Mr. Wrench. And the point is, Mr. Hyde could not do that. He could not do that because that £1,000 offer that he made originally was destroyed. It is deceased. It is gone by that counter offer which came through from Mr. Hyde. So that is the fundamental takeaway here. If a counter offer is made, any previous offers are null and void. They cannot subsequently be snapped up if you're not happy that someone refused your counter offer. So that is the premise that you must understand and take away from Hyde and Wrench. Having established the principle from Hyde and Wrench that a counter offer destroys any previous offers, we're now going to distinguish that from a very different thing, and that is a mere request for more information. The key takeaway from this slide is this. A counter offer, Hyde and Wrench, see the previous slide, will destroy any previous offers that had been made. But a mere request for information won't. A mere request for information to clarify some part of an offer will not destroy that offer. It will still be there and it will still be capable of being accepted at a later date. So that's the key takeaway here. And that very much is summarised and explained by the facts in Stevenson, Jack & Co. And McLean from back in 1880. So in terms of the facts of that case, McLean made an offer to Stevenson, Jack & Co. on the Saturday. That offer was for a certain amount of iron work, 3,000 odd tons, in return for 40 shillings. So I've got some iron, I'm going to sell it to you, I want 40 shillings for it. That was the offer, and he said, I want to hear back from you by the Monday. All good. Flash forward to the Monday morning, Stevenson, Jack & Co. opened up the Telegraph and they received the offer saying 40 shillings for the steelwork, and they said, you know what, we need to clarify this. So they issued a request for more information to Mr. McLean, and they asked him, would you be willing to spread the payments of that 40 shillings over 2 months? So again, they were only asking a clarification. It was a mere request for more information. It was not a counter offer. They were not trying to haggle him down to 30 shillings or 35 shillings. It was only asking him to clarify whether he would take payment in a different time frame. That was fine. They issued that clarification in the Monday morning, didn't hear anything back, and decided, you know what, let's just accept the original offer. We've got the money, let's just accept it. And they did that on the Monday afternoon. So again, very narrow time frame here, but they accepted the original offer in the Monday afternoon. That's fine, because the mere request for information didn't destroy the original offer. It was still there, still capable of being accepted, and that's exactly what they did, forming the contract. The problem was Mr. McLean had already sold the iron, and at that point he could not then give it to Mr. Stevenson, Jack & Co. And they ultimately took him to court for that, sued him for breach of contract, and they were successful because they were able to prove that what we asked on the Monday morning was just a clarification, just a mere request for information. It didn't destroy the offer. We were still able to enter into that contract. Therefore, he should have provided us with the iron work. But he couldn't do it because he had ultimately sold it on, and they ended up taking him on for damages to compensate them for any profit that they would have made on the iron work. But we'll talk about damages and how to calculate them in a later video. So hopefully that case really does make the distinction between what a counter offer is, look at Hyde and Wrench for that one, and a mere request for information, where we have Stevenson, Jack & Co. and McLean. The third and final requirement then for a valid acceptance is the need for it to be communicated to the offeror, the person who made the offer in the first place. That's our general rule. I would always recommend, if you're answering this sort of question in an exam or a piece of coursework, always start by stating that general rule, that acceptance must be communicated, and it must be communicated to the offeror. The case that people typically cite for that general principle is Ontours and Miles Far East Corporation of 1955. It's not a particularly exciting case, but it is a Lord Denning decision, and in typical fashion he explained this legal principle by way of a colourful analogy, which is exactly what I have animated on the screen for you. So the facts of this case: Mr. Greenshirt made an offer across the pond to Mr. Blueshirt, and this is all about Mr. Blueshirt trying to accept that offer. So what Mr. Denning described, or what Lord Denning described, was it's not good enough to shout that acceptance across the river. You must ensure that that acceptance is communicated and heard, because if an airplane was to fly up that river and the noises of the jets were to drown out that acceptance to the extent that it was never heard by the offeror, then no contract has taken place at this point. Again, it's a bit far, it's a bit off the wall in terms of how you would describe this, but it does make perfect sense. If that acceptance is not communicated to the offeror, then no contract has formed, because communication is absolutely vital. Now that everybody understands the general rule from Ontours and Miles Far East Corporation that an acceptance has to be communicated to the offeror, we're now going to look at some of the other factors that you need to understand as well, such as, does silence and can it ever amount to an acceptance? Can you stipulate a manner in which a communication is to take place and in which an acceptance is to take place? So these are not quite exceptions to the general rule, but they are an extension of that, and there are other factors that you must be aware of, because they can and will arise on the facts that you will be given in an exam, a piece of coursework, or in real life. Looking first then at whether or not silence can ever amount to acceptance of an offer. So as you can see on screen, there's two different answers to this question, depending on whether or not you're talking about a bilateral offer or a unilateral offer. So just to remind ourselves of what we've talked about previously, a bilateral offer is an offer which is in the format of a promise exchanged for a promise. So looking at Feldhaus and Bindley, for example, that was all to do with the sale of a horse. The nephew had made an offer to the uncle to purchase his horse off of him. The promise on the part of the nephew was to pay money for the horse in exchange for the promise on the part of the uncle to give him the horse. So that's what a bilateral offer is. It's a promise in exchange for a promise. And in that scenario, you cannot ever have silence amounting to an acceptance. Again, we'll look at Feldhaus and Bindley as an example of that. So the nephew made an offer to the uncle to purchase a horse off of him for 10 shillings or whatever the money was. He also set out within that offer, if I don't hear from you, Mr. Uncle, by the weekend, I will consider the deal to be done and I will consider the horse to be mine. So that is the point. You cannot do that. Silence can never amount to an acceptance. So it was the nephew who was making the offer here. I want to buy the horse off you for this amount of money. If I don't hear back from you, I will consider you to have accepted it. So the point is what happens if the uncle just forgot about the arrangement, or what happens if he didn't understand the offer or didn't hear it? And that is why silence cannot amount to an acceptance in a bilateral arrangement. On the other hand, we have a unilateral contracting arrangement, and we talked about this previously with respect to the case that we have on the screen there. A unilateral offer is not a promise in exchange for a promise. That's a bilateral offer. A unilateral offer is a promise in exchange for a specified act. Again, hopefully you remember the facts of this case. So the promise in Carlisle was for £100, and the specified act was taking the medicinal smoke ball in a certain way. And the facts of that case play neatly into this point as well, that you can accept a unilateral offer by silence. You don't have to communicate your acceptance of a unilateral offer. Mrs. Carlisle, again, if you're not familiar with the facts of this case, please refer to the previous video. Mrs. Carlisle did not have to communicate her acceptance, or did not have to communicate to the smokeball company that she was going to take them up on the offer that she had in the paper. Merely performing the specified act of taking the medicinal smoke ball was all she had to do to accept the unilateral offer. So again, promise in exchange for a specified act. She carried out the specified act, therefore they have to fulfill their promise. So that's why there's a difference between a unilateral arrangement and a bilateral arrangement. I do appreciate that, again, I explained it in the last video, that for me, understanding the difference between a bilateral contract and a unilateral one was difficult at the time. So please do, re-watch this part of the video until you're fully confident with the difference between those two arrangements. Our next question then is whether or not a third party can communicate acceptance. So we have the offeror who makes the offer to the offeree, and this question is all about whether some third party can communicate the acceptance on behalf of the offeree to the offeror. And the answer to that is yes, but that third party must have the due authorization from the offeree. So they must be duly authorized to be able to accept that offer on their behalf. And this sort of links back to one of the first principles that we talked about, that communication of an offer has to come from the offeree to the offeror and has to be communicated in that direction. The case that we have for this one is quite straightforward, of Powell and Lee. Mr. Powell, who was a teacher, made an application to the committee of managers within a school to become the headmaster. And he heard through Chinese whispers from one of those committee members that he had got the job. So he was dead chuffed with that. But then the committee changed its mind, and Mr. Powell took the committee to court effectively to say that, you know what, that agreement had already been done, there's a contract there, because they communicated their acceptance of my application back to me. But the court threw out the case and ultimately dismissed his case because that communication did not come from an authorized committee member. It just came out via Chinese whispers. He was not duly authorized to make that decision and to communicate on behalf of the committee. So ultimately, no acceptance took place because that committee member was not duly authorized and they were not able to communicate it to the offeror, who was Mr. Powell in this case. Marching on then to our next question, and that's whether or not you can communicate an acceptance of an offer via the post, by placing an acceptance into the post box. That's what this question is all about. And the answer to that is yes, and that is our inroads into what's known as the postal rule of acceptance, or just the postal rule, established in the very early case of Adams and Lindsell back in 1818. What this rule is all about is as soon as you place a valid acceptance into the post box, that is the contract formed. You don't have to make sure that it is communicated to the offeror. As soon as you place the acceptance into the post box, that is the contract forming. The offer has been made and that is you accepting it. Now, that sits slightly at odds to the general rule that we discussed previously with Ontours and Miles Far East Corporation, that Lord Denning decision where he talked about screaming the acceptance across a river. That case was all about making sure that the offeror had the acceptance communicated to them so that they were aware of it. But this postal rule sits completely at odds to that. The offeror does not have to have knowledge of you posting that acceptance. They don't even have to receive the letter, because as soon as you post that letter into the post box, as soon as it hits the bottom of the big red post box on the corner, that is the acceptance and that is the contract forming. So that is what we mean by the postal rule. So now that everyone is dead comfortable with what the postal rule is, that rule that when you place an acceptance in the post that the contract forms, we're now going to look at a couple of other factors that you must be aware of, because these very much do go hand in hand with the postal rule itself. So the first one is dead straightforward, that the postman doesn't count. You must place the letter into a post box or into the hands of someone duly authorized to receive mail. That is not a postman. They deliver post, they do not receive it. So that's the first thing to consider, that the postman does not count. The next one is very important, and that's that the postal rule does not apply to the revocation of offers. It only applies to an acceptance of an offer. We looked at that principle previously in the last video when we looked at the case of Bern and Van Tienhoven. So just to remind ourselves, Bern was based in Cardiff in Wales, and they made an offer across the Atlantic to Van Tienhoven based in New York City. Bern then decided, you know what, I don't want to sell that tin anymore, I'm going to revoke my offer. And they placed that revocation letter into the post to go transatlantic. And the point is, placing that revocation letter into the post did not destroy their offer that was already made to Van Tienhoven. Placing a revocation into the post does not have any effect. The revocation must be communicated to the party to which the offer was made, the offeree. And that is different to acceptance, because as soon as you place the acceptance into the post, that is it deemed to be communicated, and that will be the contract forming at that point. So please do understand the difference between a letter which revokes an offer and a letter which accepts an offer. They are very different. In the case of Van Tienhoven that we illustrated in the previous video is the case for that. The next point is the fact that the postal rule applies regardless of whether or not the letter is actually delivered. It doesn't matter if the letter gets lost, or in the case of household fire insurance, if the office building burns down and it is destroyed, that does not matter. As soon as you place that acceptance letter into the post, that is the contract forming. So it doesn't matter if the letter is lost. The next point is the fact that the postal rule will only apply if it was reasonably contemplated by the parties at the time that that would be a way in which the offer could be accepted. So that can be seen as a bit of a get out of jail free card. But at the end of the day, it's going to be very difficult to establish that accepting an offer via post wasn't in the reasonable contemplation of the parties at the time. And that links into the final bullet point then, that the rule can actually be ousted by the offeror. So if they use very clear words within their offer that I will only accept an acceptance letter in a specified way, say for instance via email, then you have effectively ousted the postal rule at that point. That point we will talk about in more detail shortly when we look at specified or stipulated means of accepting offers. Our penultimate question then is, can you communicate the acceptance of an offer via instantaneous means such as telephone or text or email and so on? And the answer to that is a resounding yes. And that just follows the general rule that we discussed previously in Entours and Miles Far East Corporation. Where this can often become a problem is trying to understand where the contract actually came into formation. And that's another principle that we had established in the Entours case. And the answer to that is the contract comes into formation where the acceptance was communicated. So if I make an offer in Wales, again using our Bern and Van Tienhoven facts, if I make an offer in Wales across the Atlantic to New York, and I receive an instantaneous means of communication back the way, I will have received that communication back in Wales. So if they accept it over telephone or they accept it via email, I am deemed to have received that communication in Wales, and that is where the contract is deemed to have formed. That's subject to whatever the contracting parties have agreed between themselves, but that is it in the common law position. And that is what we also have from Entours and Miles Far East Corporation. What we also have here is just for confirmation that emails are not subject to the postal rule. You're not accepting as soon as you hit send. It's all about it being received in the recipient's inbox. And again, the general rule is if I make an offer in Wales or wherever for that matter, across to somewhere in New York or somewhere else, it's receiving that email back the way. It's when that communication is made, that is where the contract forms. And in that scenario, it's our Welsh contract. Moving on then to our final question, which is, can you stipulate a method of communicating an acceptance? And the answer to that is yes, a resounding yes. So if I am the offeror, the person making the offer, and I make you an offer, I am free to stipulate within it how you must accept it. So if I'm making an offer, I am free to dictate how you must accept that offer. So that's what the rule is all about. If I did want to avail of that stipulation and to make such a stipulation, then I must be very clear in the words that I use. The case of Manchester Lyceum Council confirms that for us, that if you want to rely on a stipulated means or method of communicating an acceptance, you must be very clear as the offeror in how you draft that. Because if you're not, and you're not particularly clear and you don't use mandatory language, then the offeree, which is you in this scenario, would have the ability to accept it in whatever way you want, as long as I wouldn't suffer a detriment as a result of that. So to use our example, if I made an offer to you and I stipulated that it must be accepted via post, and I wasn't particularly clear with my drafting, and you come back via email, I would be bound by your acceptance as long as I didn't suffer some sort of detriment due to the fact I received it via email, which would probably be the case. It's hard to see why you would suffer a detriment receiving an acceptance via email instead of via post. But the point is that you can stipulate whatever you want if you use very clear terms. That fallback mechanism under Tin and Hoffman, where as long as you accept it in an equal or approved way that doesn't cause the offeror to suffer some sort of loss, then that would be fine. So hopefully that makes sense, and hopefully you understand how you can stipulate a method of communicating an acceptance.